Stetson University.
I'm delighted to be welcoming back Jen Metz, who graduated in '09, as recently as '09, in psychology and is now pursuing a master's in mental health counseling at Rollins. And our speaker of honor today is Cory Sutter, who graduated with an American Studies and Political Science double major in '08 and is now pursuing his law degree at Stetson Law School. So in addition to the content that he presents about, he also presents an opportunity for you to talk about that bridge from undergraduate days to law school and beyond.
And beyond.
And I remember Cory best as a student that I learned from. That he always brought out the qualities in the classroom to make teaching and learning be a conversation. And he was so adept at that. And I'm envious of his law school professors because I bet he's doing the same thing now in law school. And you know, I'm fond of making reference to the liberal arts as fields of study that don't have direct connection with particular practical applications of things that your parents and many of you are worried about for good reason about getting a job later after your undergraduate days. But you know, what we're up to in the undergraduate fields of the liberal arts is not particular training for particular positions, but it's about a quality of thinking and quality of mind and asking critical questions and developing skills that you can apply in lots of different directions. And Cory Sutter embodies that. He embodies those skills and acquisition of learning, because I remember when we first met, he was a political science major, and he took such an active interest in his education, he began to ask the question that I represent to many students in my classes and my advisees, that I'm a hired hand. You're the chair of the board of your education. I'm a hired hand. Hire me on if I can be of use to you for the enterprise that you're developing and formulating your vocation. So he did that with me. He said, hey, I have a political science major. I'm learning about political processes. I'm going to hire you on to help me understand culture. And I said, okay, let's do that. And the conversation continued. So I'm looking forward to hearing how this thread of the conversation continues, because it's always been fun.
Yeah. Thank you for that introduction. Like you said, actually this is my last semester of law school. I've been through all the ropes and ringers. I took a class specially designed on the First Amendment, which this lecture is basically going to focus on. I'm actually going to hand out two cases. In case anybody is interested in law school, I'm going to basically hand out two cases to pass around so you can see what you're getting yourself into. And this is exactly what people are reading as far as law school is concerned, and what people are using in their everyday life to prosecute and to make cases. But this focus today is going to be on religion and science, creationism versus evolution and the First Amendment, and when all of those come together, what happens in a practical sense. And if you have any questions at any time, please feel free to raise your hand and jump in. Why are we here? Creationism and evolution as a whole are very amorphous. They just seem like broad ideas that you can learn about in, a college setting. But how do you apply them to everyday life? What impact are they going to have, except for framing your worldview and maybe a heated discussion over, a beer or a glass of wine later on in life? The next line, Pandas, People, Judges, and Judgment Day. We'll see that there's this book called Pandas and People, and they use this as a vehicle for intelligent design teaching in the classroom. But the idea that people and pandas may or may not be related, and the fact that it translates into an educational setting, brings out judges, brings out people to advocate for rights, whether it be the right to have religion or the right to be free from religion. And then it leads to implications of, are you being judged during the afterlife, or are you being judged today when a court case is being ruled upon? And lastly, what is the practical application of this knowledge? Anything that you gain in your liberal arts education, or even in your business education or science, math backgrounds, all of that are just the building blocks necessary to fully encompass what you're going to do practically in the rest of your life. These little tidbits that you find here and that we're going to discuss today are just small little pieces that actually can have a major, major impact later on in society as a whole, well beyond just what you have learned. So we're talking about the First Amendment and religion. The First Amendment, the line that we're considering here is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. One interesting tidbit that most people don't actually know and very much so mess up is the First Amendment only applies to government actors and actions. If a private institution tries to limit your free speech or puts restrictions on your religion or forces you into a certain religious setting, that's fine. The First Amendment only considers state and government action, so just be aware of that. There are two major clauses of the First Amendment, specifically with the religion clauses. There's the Establishment Clause and the Free Exercise Clause, and as you can see, they're basically flat out displayed in the language themselves, an establishment of religion and the prohibiting of free exercise thereof. The Free Exercise Clause, which is the second half, basically deals with government and their actors restricting what you can and can't do, such as a law prohibiting sacrifices of goats or something, which was an actual case out of Miami that reached the Supreme Court, or laws regarding when you cannot do things on Sundays. Then there's the Establishment Clause, which is pretty much exactly what creationism and evolution in schools is tailored around. It also has to do with the Ten Commandments being in schools, prayer in schools, prayer or national monuments with religious symbols on them. And the courts look at the basic language of Congress shall make no law respecting an establishment of religion to decipher whether or not religion is being brought forward by the government, either inhibited a certain type of religion or whether it's promoting a certain type of religion. Back in the 70s, they came up with this test. It was from the case of Lemon, basically. Lemon v. Kurtzmiller, I believe is what it's called. And they came up with this very amorphous test. And that's what the Supreme Court does, is they kind of come up with a bright line test or factors that lawyers argue about constantly based upon Congress shall make no pass regarding the establishment of religion. They created this test. And it's 3 parts, and in order for the government to succeed in its actions, it must show that none of these parts are applicable to that action. The statute must have a secular legislative purpose. This basically means that the statute can't be fundamentally wound up and wrapped in or cloaked in an idea that religion should be utilized or prohibited in some manner. If it doesn't have a secular purpose, then it automatically fails the Lemon test, and the statute or the law as a whole will fail. The second part, which is actually what we're going to talk about the most today, is the principle or primary effect that must be one that neither inhibits or advances religion. In that instance, if it has a secular purpose, the statute has to do with requiring equal time of evolution and creationism in schools. The secular purpose would be to show that all information is accessible to students. That's a secular purpose, okay? But if the primary or principal effect is that it advances a religious idea or inhibits a religious idea, then it also fails. So the legislatures a lot of times will put forth various statutes, whether it be a state legislature or Congress, and they will say, all right, we want equal time. We have this secular purpose along the ideas of we're just trying to promote the general knowledge of students, which is a secular purpose because legislatures have the right to hope that their students are educated. But if the primary effect of that is to advance religious ideas, then it will also fail. Lastly, the statute must not foster an excessive government entanglement with religion. These are all very amorphous tests, and they kind of blend in with each other. But if there's an entanglement with government and religion, such as the passing of one idea versus another idea, or the express implications of government controlling a religious idea and then passing it on through its actions, then the third prong will be met. If one of these prongs is met, then the law will be found unconstitutional. And as a whole, the religious purpose must not continue to go forward. The case versus Edwards v. Aguilar. This is basically a seminal case, and it's actually one of the cases that I was passing around. It was decided in 1987, and in this case, this has to do with the Louisiana legislature passing a statute that required creationism and evolution be taught. They didn't require that evolution be taught at all, but if it was taught, creationism had to be taught, with the secular idea that if one is taught, we're just furthering the education of students, such as I've mentioned previously. So the issue is whether the Louisiana statute violated the Establishment Clause and the Lemon Test that I just previously discussed, and what implications it has on the First Amendment. The court went through some analysis, and as a whole, it found that the statute did violate the First Amendment because it used the government to achieve a religious purpose. And actually, just as a practical side note, this is basically what you're expected to do in law school. You're expected to pull out the required facts, pull out what's the point of this entire case, and then why the court held, or what the court held, and then later on explain why the court held it that way based upon those facts. They went to the Lemon Test when they did this. The Lemon Test, they only considered the first prong, because if it doesn't fail, or if it fails the first prong, then it fails the entire test as a whole. What is the actual purpose of the government's actions? That is the quintessential question which the court had to frame the entire discussion. If it's to endorse or disprove religion, it's unconstitutional. So if it's passing forth ideas that say, you know, Southern Baptist is the way to be, you can only be Southern Baptist in this way, or if it's saying you can't be Southern Baptist at all and putting some sort of restriction on that, then it's not constitutional and it will not have a secular purpose. The statute gave various resources to the Board of Education in that instance. They said that only creation scientists could serve on the resource panel, which would provide books, materials, lectures, and teachers to teach various creation science ideas to the students. However, nothing was provided for various evolution scientists and normal biology, what would be considered normal biology institutions, and no resources were given to those teachers. They found that creation science included a belief in the existence of a supernatural creator. The fundamental idea behind creation science is that there's something about it that can't be explained as to why people are so much different than dogs, cats, pandas, microbes. And that missing link that everybody's always talking about, where's that? We are inherently more complex than anything that has ever walked the face of the earth before, and therefore something had to make us that way. It's impossible that a mere random series of events caused us to become smarter and better than everything else on the planet. Therefore, an intelligent designer must have come across this idea to put us in motion to become the most successful creatures on the face of the planet. They define it as origin through abrupt appearance in a complex form. If you think of a normal Darwinian tree, it's literally the tree of life, all stemming from one point and branching outwards. Well, creation scientists think of it as one thing starts here, down the road, another thing will start here, and work its way along the lines, and they are abrupt in their creation, which signals that an intelligent designer actually created and thought of what should happen on this earth. The Establishment Clause in that case, they found, was definitely violated because it forbids both a preference of a religious doctrine as a whole, the clause forbids this, or it forbids the prohibition of a theory which is deemed antagonistic to a particular dogma. In the Louisiana statute, it clearly favored creation science over evolution science. Again, returning to the fact that the board only had access to creation science materials, only had access to resources for creation scientists, nothing for normal biology and evolutionary standpoints, then as a whole, that dogma would be antagonized by the teaching of evolution. And that violates the spirit of the First Amendment and the Establishment Clause as a whole. And the court went on to say that because it clearly prohibits a theory which is antagonistic to a particular dogma, in this case Christian Science and Christian belief in how people came to be on this earth through the book of Genesis, then it violates the Establishment Clause. And as a whole, the statute cannot succeed and continue to be maintained as to regulate what education the schools can teach their students. This is the next example, and this is actually what I will be showing a little clip on a movie on, and it's another case that I passed around. This case was huge as far as the evolution versus creationism theories. We have a school board that wanted to include intelligent design in science class. And there you'll actually see a remarkable shift in thinking. First, it was creationism, which the courts as a whole in Aguillard found that creationism is just a front for religion. Well, then they crafted this idea of intelligent design, where intelligent design is removed from the annals of God and just more along the lines of a being, someone who did create this, but we can't prove it. It's more of less of a faith-based idea and more of just a philosophical idea. But they were couching this in a way that it was scientific and could be shown through disproving other theories that this was the only theory that actually was applicable. They wanted to use this book, Pandas and People. The book included intelligent design as a theory that completely contradicts Darwin's theory of evolution. Now, Darwin's theory of evolution has to do with the idea that we came from the primordial soup, and over millions and billions of years we split off where various factors were taken. Natural selection is one of them. Natural selection being whoever's most successful in that environment, those traits will be passed on because that creature will survive longer than other creatures. An example that they give is Darwin sees finches with various sized beaks. And on one island, there's lots of large nuts, and on one island there's lots of small nuts. And he found that the island with the large nuts, the finches have larger beaks so they could crack the nuts, whereas there was a very short supply of birds with small beaks because they couldn't survive off of those. Regardless, on the other island, there was lots of small-beaked birds because all the nuts were small on that island, which shows that the small beaks were all that was necessary, and therefore the larger beaks need not be passed on. That's an idea of natural selection. What this school board wanted to do is they wanted to say, wait, this is a theory. There's gaps in this theory. There's nothing to say that this is actually true. There's nothing to actually prove it. In fact, there's so many missing links that calling it a theory is a stretch in the first place. But we have a theory. It's called intelligent design, and it fills in those gaps, and therefore is a much more successful scientific proposition to be used in the classroom. And at the very least, they should be taught side by side. They required a 1-minute statement stating that Darwin's theory has these gaps, and they were going to read this to all incoming 9th grade students in their Intro to Biology courses. A lawsuit was instituted by one of the 9th graders' mothers, and the ACLU got involved. Not only did the ACLU get involved, but the school board contacted the Thomas More Law Center, where the Thomas More Law Center is known as an advocate for religious and Christian values in the legal world. They actually use law to help further Christian beliefs, which is a good thing if you believe in Christian beliefs, but what they were trying to do was couch science in a way that legally seemed different than the Aguillard case, so that it could show that the First Amendment was not violated by the school board's actions. In this case, both the defendants, who was the school board, and the plaintiffs, who were the mother and the science teachers, asked for the court to define intelligent design. They actually asked for what intelligent design means, whether it is science or religion or some philosophical idea. And if it is religion or some philosophical idea, inherently it would violate the Establishment Clause. This kind of gives a background as to what is being talked about. The video that I'm going to show does some reenactments as to what practical applications happened in this case. And some things I would like everyone to focus on are the ideas that you need a broad knowledge of evolution and creationism, but you can gain practical knowledge that will help you, in this case, impeach or bring forth evidence that show whether or not someone is actually harming or hurting the system through violation of the First Amendment. There's actual practical application to the very broad knowledge that you can gain through these various theories and other liberal arts teachings. That gives a nice little overview of what is used at a case to prove the connection between these broad theories of evolution, creationism, combined with this very ephemeral test that the Supreme Court literally just made up while analyzing what actions would violate the Establishment Clause. And it shows that not only do you need to have some sort of general overview as to the way things work, but you need specific evidence. And there was a number of tactics that were used to show the specific evidence that was translated from that broad overview of creationism and evolution. The court found that intelligent design is not a scientific theory, effectively making a judicial ruling that not only is intelligent design creationism, but intelligent design is not a scientific theory, which kind of lends weight to the fact that no other school board will be able to throw their hat in the ring saying, we're just teaching intelligent design, which is an acceptable scientific theory. If they get sued, this case will be the first case that is plopped in front of them saying, are you sure about that? Because what cases do is they create precedent. And this precedent is what is used by lawyers on both sides to argue whether or not the facts in their situation are applicable to those facts where the rule of law has already been decided. And in this case, the rule of law is intelligent design being taught in schools violates the Establishment Clause and therefore is unconstitutional against the First Amendment. It violated the First Amendment because not only was the Establishment Clause implicated, but the Lemon Test was failed. The school board's actions had a primary purpose or effect of advancing religion. This primary purpose or effect has to do with the school board trying to advance intelligent design, not as a scientific theory, but as a cloak for creationism, which is inherently religious in its belief system. There were a few effects of this ruling, and actually right prior to the ruling, this destroyed the town of Dover, which is a small Pennsylvania town. It basically, what they say in the video earlier on, is this was a civil war between sides. You have a very high fundamentalist religious group in Dover, and then you have a more modern view and reformed view of religion. And this tore them apart. It literally put neighbor against neighbor as to what was the correct actions for the school board to take. They voted that school board out by a narrow margin, but they removed every single creationist on the school board and instituted non-creationists on the school board to further what was considered, by the community standards, actual science. After the ruling, the judge, Judge Jones, which you saw, he received death threats. That's the kind of implications that this had on the community as a whole, and the kind of things that when you graduate and when you partake in various activities, the kind of impact that you can have on society. Robert Patterson, who is a major religious figure, right-wing fundamentalist religious figure, he's mostly noted for saying that people have deserved various disasters because of their quote-unquote heathen lifestyles. He basically said on his national news programs that if Dover experiences a disaster, do not turn to God because you have forsaken him by voting out these creationists in your schools. And the fact that the judge ruled in your favor means you've turned your back on God. And that is the kind of impact that creationism versus evolution and the legal system and all of this combined will have and can have on society. And it's just a little tidbit that I want everyone to keep in the back of your heads as you move forward is your actions will create a ripple somewhere down the line. How big of a ripple depends on what actions you take and what the subject matter is you're dealing with, but it will affect something somewhere down the line. Going back to those trial tactics, and what I wanted everybody to focus on was what practical application did they use? Well, not only did they have the drafts of Pandas and People, which were clearly different, and they were definitely trying to skirt the lines before Aguillard, which decided creationism is not allowed in schools, and after Aguillard. They tried to skirt the system and just get around it by saying, well, we're going to call it a scientific theory now instead of calling it creationism. That happens a lot in the law, and this is why various suits which seem to rule on the same thing over and over again are always shown. There's another part where the Dover expert, Mr. Behe, or Dr. Behe at the end there, claimed that there was no explanation for the human immune system. It was simply too complex. Well, in the case, the prosecution, or not the prosecution, the plaintiff actually brought forward mounds of books, piling on the evidence of various people discussing whether or not the immune system was too complex to be formed naturally. And that destroyed his credibility on the stand. And that's something that lawyers attempt to do, is they try to have you say something, and then the other side will get up and try to destroy your credibility, make it seem like, well, you're not as trustworthy as we originally thought you were, so what you were saying might not be true. We have the digging of records. We have the newsletter that was given out and read by Barbara Forrester as well. And these are the kinds of things that you have to go out and do research on. You have to dig for these little tidbits. Factual evidence is actually the biggest part of the case. You can rule on matters of law all day long, but if the facts in your case don't show why you should rule that way, then it won't work. It plainly does not matter. So that is the practical application of the trial tactics and what is necessary to create that bridge from creationism and evolution, the law, and then everyday life and how you prove the law applies to evolution and creationism. And lastly, just some major takeaways, as I've kind of echoed throughout this entire thing. You need to balance yourself. You need to balance practical knowledge, and you need to balance book smarts and theoretical knowledge. Because if you can do that, then you can apply it in such a way that will have a major, major impact, not only in the academic world, but in society as well. You can change the law. You can fight for various belief systems, whether it be religious, whether it be scientific, what have you. But if you don't have a balance between theoretical and practical, you're not going to get anywhere. Lastly, one last takeaway is that the law protects your rights. You can use all of your ideas to implicate the law, and the law is there to help you move on your way. Lawyers get a bad rap for being, uneven-handed and things like that, but essentially what they're trying to do is fight for the system that they think is right for their client. And as people that are going out into the world, professionals, business experts, things of that nature, you're going to come across and need the legal advice of various people. And combined with your knowledge and their knowledge, you can effectuate any type of change in this world that you feel is fit. So that's my presentation on evolution and creationism and the law. And if you have any questions, I'd be more than happy to take one. Any questions? Well, thank you for your time. Question?
Occupational hazard. I have a question. One of the things we've talked about in a couple of my classes on the 50s and 60s and on science and religion is about a precursor to intelligent design. Coming between creationism and intelligent design, this idea of young earth creationism. Mm-hmm. And that these are folks who began the step of an eagerness to find that their beliefs had scientific bases to them. Mm-hmm. Did you find any evidence of either in your historical research here or in your legal research of young earth creationists having a factor in the legal cases?
Actually, yes. I believe it was in the Kitzmiller v. Dover case they actually go through it's a very long case, as you might have felt when you picked it up, but they go through a historical reference as to where these ideas of creationism originated from. And Darwin's theory of evolution came about, what, in the 1890s, 1800s, late 1800s, early 19...
1959 was the first publication.
Yeah, and it really caught steam during the late 1800s, if I remember correctly. And right about then, and then going into the 1920s, the 1930s, there was this huge upsurge of fundamentalist religious beliefs and kind of bringing the nation back to its roots and the ideas that this is a Christian nation. And from there, they talk about moving into the 50s and 60s, this holding down of biological and scientific ideas in order to foster those fundamentalist religious ideas. And actually they talk about a dearth of information that is withheld from people of that generation, where they're actually more, to use a word from the documentary, indoctrinated as to what fundamentalist ideas are the right way to see it. And it is not until recently where the courts have actually gotten a hold of this and tried to prove through the First Amendment that creationism, young earth science, and what intelligent design actually implicate the First Amendment, which means that the government is taking, or government actors such as a school board is taking the reins in fostering that religious movement, and that simply is not what our Constitution will allow. Yep.
Socially, when Christians are no longer the majority religion, do you foresee them more supporting the current laws or supporting more strict laws so a new dominant religion cannot encroach further on their beliefs?
That's the beauty of the First Amendment. And to answer your question kind of roundabout, in a roundabout manner, the beauty of the First Amendment is it doesn't matter what religion. It doesn't matter if it's Christian, Islamic, Jewish, Hindu, it does not matter. Government as a whole cannot take any actions to prohibit or put forth what would be the accepted religion. So if Christianity falls out of line and we become, a Tibetan nation, it wouldn't matter, as long as our government is not making those actions. Now, if again, private actors can put those restrictions on you, so such as Stetson used to be a Baptist college. They could regulate whatever you say and do all the time, such as like they do at BYU, Brigham Young University in Utah, which is a Mormon college. They have all kinds of restrictions, but they're allowed because they're a private institution. But that's the beauty of the First Amendment, is if one religion falls out of favor, it doesn't matter because the government shouldn't be taking those actions anyway.
So you believe they would more support the current laws and not try to...
Yeah, it's kind of that idea that when you're out of power, you challenge it, and when you're in power, you don't want it to be challenged. So the fact that this country is largely a Christian-based nation, they don't want to be challenged on putting forth their ideas. But if it would flip-flop, they're definitely going to want to be protected in their minority status. And that's also part of the beauty of the First Amendment, is it does protect the minority status. That's why you can have so many sects of Judaism or Hindu or what have you in America, is because the minority is protected through the First Amendment as far as government regulation is concerned. Any other questions?
Does anyone have anything else? Because I'm thinking of one that came up in a couple of our classes when talking about conservatism in the 60s, feeling beleaguered, a minority, feeling that secular, liberal, and radical ideas were getting a lead. And in our science and religion class, people who are members of Christian denominations feeling that there is an establishment. There is an establishment in this country. It's called secular humanism. It's called scientific secular humanism. So just to play the devil's advocate, how does the law deal with that conservative-based, but members of the American citizenry who look at these decisions and just say, there it goes again. secular, liberal, and scientific liberal ideas rule the day, and they're able to steamroll over traditional American values because they're the ones that are establishing.
That's actually a really good question. The fact, this again turns on what the First Amendment and the Bill of Rights can regulate, which is government actions. The response to that would be, you're a private individual, you can go set up your private institution, you can go forth and conquer on your own, but we will not allow the government to do that for you. The fact that science, math, and liberal arts worldviews, they're not religion. They're not even close to defined as religion, and the Lemon Test would be used to determine whether or not it is religion, but it'd be hard-pressed to find philosophy or math or science as religion. So therefore, it's not implicated by the First Amendment. Additionally, the Kitzmiller Court, the Dover Court, noted that, especially in middle schools, elementary schools, and secondary education, the fact that children are there involuntarily, they have to be there by law, creates a much higher level of scrutiny that the court must use on government actions to make sure that the court is not putting forth one set of ideas over another set of ideas in a religious way. So because they're there involuntarily and they're much more scrutinized as to what actions the schools can take, such as even not allowing a moment of silence in some instances, or another big issue is the under God and the Pledge of Allegiance and allowing students to abstain in that matter. So as the devil's advocate, it would be, you're a private individual, you can go forth and conquer and put forth your ministry in your own way, but the government's not going to have their hand in it.
And so this idea that secular humanism is the establishment doesn't have legal standing.
No, that's actually the perfect words. There's no legal standing for that because it's not regulated by the Constitution. I mean, you'd have to pass a constitutional amendment saying that secular humanism is just a fringe religious idea. And if that's the case, then everything's religious. So.
It's so general.
But this would also apply to the idea of atheism. Atheism would be considered a religious belief. So that is not allowed to be regulated by the First Amendment either. However, secular humanism, which doesn't implicate God as a belief system or the lack of a God as a belief system, is not a matter to be decided by the courts.
One of your last comments about atheism, you said that atheism is not considered legally a religion. Is that
no,
right?
It probably would be considered a religion because it's prohibiting religion. An atheist belief is technically a religious belief that there is no religion.
Yeah, okay.
But secular humanism is more of a liberal arts belief system as to human interaction is concerned, which is the study of people in their everyday life or their business and what have you, whereas atheism is focused on the lack of an intelligent being,
so that
which would be religious. Yeah.
Okay. Because that made me think of different kind of cases for conscientious objection to war, that you can.
That's a whole separate First Amendment argument under the free speech clauses, which conscientious objections actually go beyond whether or not the government is prohibiting or promoting religion. It's a separate analysis in that case.
Okay.
The way I would see it is like atheism being a religion would be like not smoking being a habit or not collecting stamps being a hobby or something. How would you respond to that?
They're different in the idea. It's always hard to make the argument that something that is not something is something, which is very counterintuitive. The fact that atheism is a belief system, and I'm not an atheist, so I can't speak for atheists, but as far as my understanding goes, that atheism as a whole believes there is no God. The fundamental principles of atheism deal with the lack of a religious or omnipotent being. Do you have a point to it on that?
It's more of a there is no God. That's where we start from. Religious people say there is a God. We say you're wrong.
Yeah, it's where
not
you're.
like we believe there is no God. We just reject you saying there is a God.
Okay, but see, the whole point is not whether there is or there isn't. The whole point goes as to what you're talking about. The point is you're talking about a God. You're talking about teaching whether there is or is not a God, which is encompassed into the idea of promoting one belief system, which, quote unquote, under the large branch religion, is implicated by the First Amendment. Does that make sense? Whereas not collecting stamps, you can't call that a hobby because you could be doing something else. It has nothing to do with the idea of a hobby. Does that make sense?
Yeah, I was thinking more of like the lack would cause it to not be one. But I see what you're saying.
You have to think of it more as atheism is not the lack of a religious belief, but it is its own separate religious belief that negates everyone else's religious belief. Does that make sense?
Yeah.
Okay.
So it's on religious turf, so to speak.
Yeah, it's on the turf. It's under the broad branch of religious belief.
Yeah.
It's just saying, no, you're all wrong over here. We're going to say no. But it's still under the system of the religious world. So it would be, if the government came out flat out said no one can believe in a God, well, that would clearly implicate the Establishment Clause in that instance, because it would be regulating whether or not a person can use religion or not. Does that make sense?
Yeah.
Any other questions? That was a good question.
Well, that ties in with what, I don't want to produce a tangent here, but this last thread is why I brought up the conscientious objectors, because of the way in which you can legitimately argue against serving in war based on religion, and I forget when, but sometime during the 1960s, I believe, there was the argument that you could make a religious argument against serving in war based on atheism or agnosticism.
You could. Forgive me, it's been a long time since I remember those cases, but there's actually an entire government board that determines whether or not you're sincere in your conscientious objection, because just using it as an excuse didn't fly, especially during the Vietnam War. And there's actually a whole nother set of legal tests that you can go through to determine whether or not a person is a conscientious objector for whatever reason. It does not only have to be religious based.
It doesn't have to be religious,
No.
yeah. Okay.
That was they carved out a small subset for that. So like a Tibetan monk clearly wouldn't be sent off to war as a conscientious objector. It just so happens that it's a religious reason.
Yeah. I was just wondering if any of the creation scientists would refer to the conscientious objectors to support their case and say, hey, someone can come up as a secular humanist and say I object to war, and that counts. Why can't we count and say that secular humanism is a religion? Again, devil's advocate.
The factual distinguishing point in that instance would be, again, what is the government doing? Is the government promoting religion? No, it's just it's carving out an exception to not send people to war. That's a wholly different idea, and that's what the court would do in that instance. Did you have, okay. So they would factually distinguish it in that terms. And what is Congress or what is the legislature trying to do with this law of conscientious objection? Oh, they're trying to determine whether or not people can go to war. That has nothing to do with religion. There's a subset, an exception that may include religious people, but we're not promoting it or inhibiting it. It has nothing to do with the promotion or inhibiting religion.
I see. Okay, that makes sense. Okay.
I thank you all for your time, and I hope you enjoyed the presentation.
Thank you. All right. Very nice homecoming. Come back again.
Yes.
So there were two.
Stetson University.